Hey everyone, Harry here to talk about Donald Trump's brief on the merits in the Supreme Court in the 14th Amendment case out of Colorado. So this is no longer the brief to convince the Supreme Court to take the case. It's rather the brief to convince the Supreme Court to reverse the Colorado Supreme Court. These briefs have there's a certain conventional structure, nature of argument, etc. We've seen in the last week how incredibly unconventional, and I guess euphemistically, Trump has behaved in court, and we've seen a lot of filings on his part that are really trashy and unconventional. This is not. It's a solid piece of work. It's not brilliant, but it's completely, of a piece with what the Supreme Court would be looking for. So that's sort of the first point. Jerky kinds of diatribes, or there's no accusations lobbed at President Biden. Whether he just let the author go forward and use that his best judgment, the author's guy, or was actually persuaded is not clear. But it's just a sober professional product. That's point one. Point two that's interesting is a departure from the cert petition arguments in favor of a few others that he emphasizes. And those were clearly strategic decisions by counsel. So the very first argument to persuade the Supreme Court to take the case was that the 14th Amendment, Section 3, lacks judicially manageable standards. This is what the court had done in the gerrymander area, saying we've got to stay out of this because it's just too difficult to apply, and we have to. You might have thought that would make sense at the time, because who would then have to do it? Congress. But as I pointed out then, it really was a bit of it had a boomerang effect, because all that really said in the federal area, like in gerrymandering, is the court is out of it. But it didn't amount to a ruling that that Congress must do it. It just said the court is out of it, and that's it's a federal doctrine about political questions, but it doesn't apply to the states. So they realized that to push that argument, if the court adopted it, would simply leave Colorado and other states to occupy the field. And they didn't want to do that. Moreover, they're arguing precedent. There's a case that figures in here that was actually written by a Supreme Court justice, though when that justice was sitting as a Court of Appeals judge. And it's in that opinion says this is for Congress to decide. And if they want to use that as precedent, it's a little hard to say there are no judicially manageable standards. So that big argument is out the window. The other big argument that is nearly out the window, they really emphasized in the petition for cert that this was not an insurrection, and they proffered basically a definition of insurrection as the Civil War, people on the ramparts in uniforms and muskets and the like. I had criticized that at the time, among other reasons, because it has been applied, 14th Amendment, Section 3, to people other than the Civil War rebels. For example, a socialist who the Congress refused to sit after World War I, determining that he had engaged in insurrection. So there's the very lightest touch. There's a sentence or two that says this doesn't have the what we think of as an insurrection, but it doesn't go through at all. What he does, however, do is make a big point about engaged. So he says, he basically, and this is sort of a piece with his kind of astounding diatribe with Hannity last night, where he said, "Yeah, so presidents go over the line; they have to have room to go over the line." He basically suggests, even if this was an insurrection, I didn't engage in it, and so, and that argument is about other people did it, and they were the ones who stormed the Capitol, and there's no vicarious liability. That means liability for things that other people do under the 14th Amendment. And also, it's a rehearsal, another statement of his argument about the First Amendment. He's really just saying some, maybe fiery political rhetoric, but that's what presidents do. And remember, he says be peaceful and all those things. So really, he didn't engage in, which is a kind of a proxy for saying that his language, his rhetoric didn't rise to the level that it would violate or it would be okay under the First Amendment Brandenburg test, because it was a clear incitement. And that's the basic flip side of the argument of whether he engaged, and he didn't, because it was just the First Amendment limit of political speech. So that's the basic deal, a solid B plus, good paragraphs, good typing and font, good penmanship. But no real surprises in the arguments that he does do, but some surprise in the arguments that he doesn't do. Judicially manageable standards, which I think is smart, and they realized that they don't want to go that way. And then backs off big time that the definition of insurrection. The thing about the definition of insurrection is it's something that the Supreme Court, which I've written and said before, has a bunch of choices, none of them great. They could try to go that way, and the legal question of what was an insurrection in the 1860s when the amendment is passed, but engaged in, I don't see how they're able to make any kind of solid determination for the whole federal system. They just don't have a record in front of them. They have what the Colorado trial court found, but if they make that their factual record, then that's kind of a disaster for Trump, because then they have the wherewithal to go forward and find the violation of the 14th Amendment by its terms. I think they have to treat the Colorado trial court as just, one trial court's opinion, and maybe there's no manifest federal error of law, but not that it's in some way a finding of fact for the entire federal system. Okay, so there we go. Now, and his lead argument, number one, and it's what a lot of people come back to, even though it is lousy, but it's, the sort of least lousy alternative is he's not an officer. And really serving that up heavily to the Supreme Court, I think, represents a strategic calculation that, to me, has some force, which is they're going to want to have an off-ramp. They're going to want to reverse the Colorado Supreme Court in a way that completely shuts down these efforts. And the officer textual interpretation of Section 3, dubious as it is, does the least harm and is the most constrained. And then the final point about the Trump brief is, the facts, and any good Supreme Court advocate pays a lot of attention to. You want to write the facts so they seem, natural and completely unskewed, but of course they're very carefully selected. And there's a real emphasis on the number of different fights like this brewing. Instead of just talking about Colorado, it's like you've got bedlam at your door, Supreme Court, and you got to do something about it. And I think that's a strategic calculation and a sound one, that's the thing that will be uppermost in the court's mind, not deciding this case in such a way that it deals with Colorado, but leaves all the other states out there to erect whatever kind of patchwork pattern they want. That is what I've suggested that the Supreme Court will be looking to avoid. Okay, so now we have, I think, 10 days until the brief by the challengers in Colorado, another few days until Trump gets a reply brief. There's also other briefs already being filed, including by legislators, federal legislators like Ted Cruz. And then the argument set up for February 8th, which is coming super fast. So this is all playing out very fast, but not playing out very clear. It's the brief does nothing to dispel the impression I've had that the court doesn't have any clear and easy choice here. If you assume, as I continue to do, that they are going to be looking to impose one comprehensive solution nationwide. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.